Hey folks, attorney Andrew Branca here from Law of Self-Defense, where we help you make better informed, more confident, and more lawful decisions in self-defense. A question came in over the Law of Self-Defense Facebook page regarding the legal liability that might be created if a person modifies their concealed carry firearm and then finds themselves compelled to use that firearm in self-defense. And by the way, if you don't already follow the Law of Self-Defense Facebook page, I have to ask why not, assuming you're on Facebook. You can follow the Law of Self-Defense Facebook page by simply pointing your browser to facebook.com/law of self-defense. That said, here's the question in full that came in as a Facebook comment from someone going by the handle Gaston Garand. Quote, "Good morning, Andrew. I just got your book, The Law of Self-Defense, and that got me thinking, if I sent one of my revolvers and had the barrel shortened to 3 inches, smoothed out the trigger, and converted to double action only, would that paint me in a bad light in the unlikely event I have to use it in self-defense? If you can't answer online, I totally understand. I hope I'll find the answer in the book somewhere." Close quote. Well, obviously, I'm happy to answer online. So the fundamental question here is whether modification to your carry gun can, quote unquote, be used against you in court. So let's dig into that. But before I dive into the answer to that question, I'd like to give a shout out to our sponsor, CCW Safe, a provider of legal membership services, what many people mistakenly refer to as self-defense insurance. In brief, CCW Safe covers a wide variety of legal expenses incurred by their members who are involved in a self-defense use of force event. Folks, those legal expenses can easily run into the hundreds of thousands of dollars. And if you don't have that kind of money lying around, the prospects for getting convicted increase dramatically. I'm a member of CCW Safe myself, as is my wife, and I encourage you to consider them as a means of ensuring that you have the legal resources you need to win the legal fight if you're ever involved in a use of force event. You can learn more about CCW Safe by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a CCW Safe member, you can save 10% on your membership by using the discount code LOSD10. That's the number 10, LOSD10, one word, when you sign up for your CCW Safe membership. Okay, that out of the way, let's dive into today's question, which is really whether gun modifications can be used against you in court. Now, anytime anyone asks me, can X be used against me in court, regardless of what X might be, my answer is always yes. And that's because prosecutors have incredibly broad discretion as to what they're allowed to argue in court in front of the jury. Now, it's true that your defense attorney may be able to convince the trial judge to prohibit a prosecutor from arguing about one issue or another, in which case that issue would no longer be available as a legal weapon with which the prosecutor can attack your claim of self-defense. But that decision itself is left to the broad discretion of the trial judge, and you never really know how they'll rule, whether to allow the prosecution's argument or to prohibit it, until you're already looking down the barrel of a trial. So as a result, we have to be prepared now for that decision to go against us then. And the arguments that can be allowed by the prosecutor can really be remarkable. Just last week, we covered an appellate court decision out of Illinois in which the question on appeal was whether it was reversible error for a trial judge to allow a prosecutor to describe a defendant in front of the jury as a psychopath, even though the defendant had never been clinically diagnosed as a psychopath. If you're interested in that case, LOSD members can go take a look at last week's Cases of the Week for February 14th, 2020, and look at the case People v. Gomez out of Illinois. And again, if you're not a Law of Self-Defense member, it's hard to imagine why not. We'll have more information on how to become a member for free, folks, later on in this content. But in that particular case, where the prosecution was calling the defendant a psychopath, even absent a clinical diagnosis of psychopathy, the defendant was convicted at the trial. And on appeal, and this was a murder trial, so he was going to jail for the rest of his life, essentially, he appealed his conviction, naturally objecting to being characterized as a psychopath absent clinical diagnosis. And he almost certainly is correct in believing that the prosecution being allowed to call him a psychopath in front of the jury prejudiced the jury against him. After all, as a simple factual matter, there was no actual evidence that he was an actual psychopath. Now, the appellate court's decision on whether it was permissible for the prosecutor to apply the label psychopath to the defendant, even in the absence of a clinical diagnosis, and for the trial judge to permit the prosecution to make this argument, the appellate court's decision was they're all good with it, and they affirmed the defendant's conviction. So a prosecutor is allowed to call you a psychopath at trial in front of the jury, even if there's no evidence that you're an actual psychopath. As another example of the broad discretion given the prosecutors to make arguments in front of the jury, during the George Zimmerman trial, prosecutor John Guy, who's now a family court judge in Florida, screamed at length in front of the jury that obviously Zimmerman maliciously murdered Trayvon Martin because it turned out that not only did Zimmerman have a CCW gun on his person, he was carrying that gun with a round in the chamber in the ready-to-fire position. Well, folks, if having a round in the chamber is evidence of malice, then every police officer in the United States, every bailiff in that very courtroom, every civilian, with rare exception, carrying for personal protection, is guilty of malice because every single one of them carries their sidearm with a round in the chamber. Certainly I do. To suggest that there's something malicious or unusual about carrying a defensive firearm with a round in the chamber is obviously ridiculous. But ridiculous it might be, the argument was nevertheless allowed to be made. Not that it helped Prosecutor Guy in the end, as obviously Zimmerman was, of course, acquitted of all charges. And folks, that's the real issue from my perspective as a lawyer. Not so much whether the argument will be allowed. We have to be prepared for the possibility that it will, that X can be used against you in court. Don't worry so much about that, because that's probably true. Worry more about whether the argument that's being made is likely to cause serious damage to your claim to self-defense and how readily your defense attorney can defend against that damage. That's what matters. Some arguments cause damage, some don't, like the loaded chamber argument in the Zimmerman trial. Some arguments can make you look bad, but they're easy to defend against. I'm not worried about those either. I'm worried about the ones likely to cause serious damage to your claim of self-defense that are difficult to defend against. Now, in the case of the label psychopath in that People v. Gomez case out of Illinois, I think that label could have been very harmful to the defendant, as the case involved a killing caused by over 100 stab wounds. In the case of the loaded chamber argument in Zimmerman, that one was so ridiculous that the defense never even bothered to argue against it. But to get back to the question of this particular content, what about arguments based on modifications to a concealed carry gun, to smooth the trigger, cut down the barrel, turn a revolver to double action only? What about those modifications, arguments by a prosecutor that those modifications are somehow wrongful or undermine your claim as self-defense, that those an effort by the prosecutor to make the defendant look bad because of those arguments? Well, the same analysis applies, folks. We have to assume that the argument will be permitted, that the prosecutor will be allowed to argue that the shortened barrel, the smooth trigger, the double action only modification means bad things about the defendant's claim of self-defense. So assume he'll be allowed to, quote unquote, use that against you in court. The real question is, how harmful are those arguments likely to be, and how easily can that damage be defended against or mitigated by your defense attorney? So with that context, there are some gun modifications that can be the basis for very harmful arguments in a self-defense case, harmful to your claim of self-defense, arguments that are difficult to defend against. And then there are other gun modifications that are unlikely to be harmful and relatively easy to defend against. And we can distinguish between these two classes of modifications by asking, well, which of them are relevant to some required element of the defendant's claim of self-defense, of which, of course, for any claim of self-defense, there's up to 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. And again, for any of you not familiar with the 5 elements of the claim of self-defense, until you know these 5 elements, you cannot understand self-defense law, because self-defense law is built out of these 5 elements. The good news is we offer a free 5 elements of self-defense law infographic that explains these 5 elements in plain English. You can get this free infographic by pointing your browser to lawselfdefense.com/5 5 elements. That's the numeral 5 elements. And did I mention it's free, folks? So also, for a deeper explanation of those 5 minutes, we also provide an optional 10-minute video micro course at that same link, also free, but you don't have to watch the video to download the infographic. Again, you can download that infographic by pointing your browser to lawofselfdefense.com/5 elements, the numeral 5 elements. Okay, back to our question. What kinds of gun modifications are relevant to those 5 elements and therefore of concern in terms of raising legal liability, undermining your claim of self-defense? And on the other hand, what kinds of modifications are not of concern? So the gun modifications of most concern to me in terms of the damage they can cause to a claim of self-defense fall into 2 categories. One are modifications that suggest a state of mind in the defender that's inconsistent with lawful self-defense. And the other category are modifications that suggest that the shooting might have been accidental or negligent rather than intentional. So let's look at each of those in turn. First, we'll take a look at modifications that suggest a state of mind inconsistent with self-defense. So in the context of modifications that go to state of mind, keep in mind, one of the conditions for lawful self-defense is that the defender had a genuine good faith belief in the need to defend against an unlawful attack. This is a core component of the element of reasonableness. But what if there's evidence that the defender lacked this required genuine good faith belief in the need to act in self-defense? What if there's evidence that the purported defender had some alternative motive, a motive inconsistent with lawful self-defense for their use of force? What if there's evidence that the defender considers himself above the law and that he's determined to seek justice and use force against others as he thinks best, regardless of what boundaries the law itself places around the use of force? Folks, welcome to the Punisher backplate, or any other imagery or statement placed on a gun from which a prosecutor can infer or argue to the jury that they ought to infer that the defendant believed himself above the law in use of force situations. Now, for those of you unfamiliar with the Punisher, this is a comic book character who acts as a vigilante, subjecting perceived bad actors to punishment without limiting himself to what the law allows. In effect, he's a criminal. Do you want to provide the prosecution with evidence from which he can argue that you, too, perceived yourself as above the law for use of force purposes, that you're, in effect, a vigilante, a criminal? Because what message does it send to have that Punisher backplate on your gun? And the same goes for engraved statements on the gun, like kill them all, let God sort them out, and wait for flash, and things of that sort. Incidentally, this caution also applies potentially to things like bumper stickers, keep honking, I'm reloading, we don't call 911, terrorist hunting permit. These are all, in effect, statements about the defendant's state of mind, and they are evidence of a state of mind that is inconsistent with lawful self-defense. So please don't modify your personal defensive firearm so that it provides a prosecutor with the kind of evidence to use against you on this key essential element of reasonableness. The second category of modifications that I worry about are those from which it can be inferred that the shooting might have been an accident or negligence rather than intentional. A prosecutor would love to be able to argue that your discharge of the firearm was not an act of intentional self-defense, but rather an accident or negligence. Why is that? It's because the legal defense of self-defense is available only for intentional uses of force against another person. If your use of force was accidental or negligent, you may be able to raise the legal defense of accident, which is a perfectly legitimate legal defense, but the legal defense of self-defense would not apply to an accidental or negligent shooting. In other words, to the extent the prosecutor is arguing that your use of force was an accident or negligent, a claim of self-defense is simply no legal defense at all. That legal defense of self-defense is off the table with respect to accident or negligence. Now, what kind of gun modifications might be used as the basis for a prosecutor to argue accident or negligence? Primarily, these kinds of modifications fall into 2 buckets. Modifications that substantially lighten the trigger to reduce trigger pull considerably, and modifications that disengage any of the safety mechanisms built into the gun at the factory. Now, many of you are lifelong gun owners like myself. Many of you probably have similar experience in competitive shooting sports, and I think we can all agree that substantially lightening a trigger and disengaging safety mechanisms certainly does not decrease the possibility of an accidental or negligent discharge, and almost certainly increases that probability. In the context of trigger pull, it's also important to recognize that this is a measurement that is easily assessed in a very quantitative way. Put a trigger weight scale on that Glock pistol, for example, and see what the trigger pull weight is. Something between 4.5 and 5.5 pounds? Well, that's probably an unmodified OEM trigger setup. If the trigger in a Glock is only 2.5 pounds, well, okay, somebody changed something on that gun to lower the trigger weight that much. It didn't come that way from the factory. And with the trigger weight reduced that much, it has a resultant increased risk of an accidental or negligent discharge. Now, note that smoothing a trigger rather than lightening a trigger is a somewhat different matter. One can smooth the trigger and make the gun more shootable without lowering the trigger weight to any substantial degree, and there's no real objective measurement for smoothness of a trigger, so it would be hard to quantify in court. Now, having said that, I do feel obliged to point out that, strictly speaking, I am aware of one company, Coolfire. They make excellent dry fire, gas-powered dry fire modification kits for carry pistols that cycle the slide as you dry fire. I know because I've seen it. They do have a mechanism they use for their own internal purposes that can quantify trigger smoothness on a graph. But frankly, I very much doubt most people are aware the device exists. I very much doubt a prosecutor would know, or how they might even use it in a prosecution. Hopefully, I haven't given the game away with this blog post. In any case, where it's easy to argue that a substantially lighter trigger might facilitate an accidental or negligent discharge, it's much harder to make the same argument for a trigger that's smoother but not meaningfully lightened. As to the issue of disengaging safety mechanisms, I'm not sure I even need to speak at this at great length. I'll simply note that you'll never convince a jury that you know more about what safety mechanisms that particular gun requires in order to be safe to operate than do the engineers who designed that gun at the factory. So it would therefore be very difficult to justify such a modification. And of course, you're disengaging something the factory says was necessary to prevent the gun from accidentally, unintentionally discharging. So obviously, disengaging any safety mechanism intended to prevent a gun from discharging accidentally or negligently can only increase the chances of an accidental or negligent discharge. It certainly can't reduce the probability of an accidental or negligent discharge. Now, having talked about those modifications that do raise legal concerns for me in terms of the damage they can do to your claim of self-defense, and how difficult it can be for your defense attorney to mitigate that damage, there are also, of course, other modifications that can be made to a gun that neither has anything to do with your state of mind, nor do they influence how the gun discharges. I'm talking about largely cosmetic things like stippling the gun, for example, or changing the sights. Doesn't have to speak to your state of mind, doesn't change how the gun fires. Installing a red dot sight. Similar modifications along those lines. Modifications that don't influence state of mind, or from which state of mind can be inferred, I should say, or don't influence how the mechanism of the gun discharges. I don't have very much legal concern about those. Now, can a prosecutor still talk about your red dot or your stippling or whatever? Sure, of course he can. But is it likely to cause substantial harm to your claim of self-defense if he does so? Nope, it's not, because it doesn't go directly to any one of the elements of your claim of self-defense. Is it also relatively easy to defend against any harm that it might cause? Yes. Okay, folks, so that's all I have to talk about gun modifications for today. Oh, to get back to Gaston Garand's specific concerns, he talked about cutting the barrel length down, smoothing the trigger, making the gun double action only. Those are all largely cosmetic variations. I mean, cutting the barrel's cosmetic. It doesn't change how the gun fires, is not evidence of state of mind. Smoothing the trigger, we've already talked about. And although converting the gun to double action only does change how the gun fires, it does so in a safer direction than would a gun still capable of single action. So that does not increase legal jeopardy. If anything, it makes the gun harder to fire accidentally or negligently. Okay, I mentioned law of self-defense memberships earlier, and I'd like to touch upon that again for just a moment. Folks, you may have noticed that we keep only very minimal law of self-defense content on social media, Facebook, YouTube, etc. That's not by accident. It's by design because of the hostility of those platforms to self-defense in particular and the Second Amendment in general. You'll only ever find one or two of our videos at a time on any of those social media platforms. That said, we have a ton of material on our own platform, Law of Self-Defense. But access to most of that Law of Self-Defense content is limited to Law of Self-Defense members. The good news is that the lowest level of Law of Self-Defense membership, bronze level, is absolutely free, not a penny. Even the first paid tier of membership, silver level, costs only about $0.25 a day, and silver includes access to our premium members only Law of Self-Defense podcast, if you're into podcasting, which I certainly am. At the very least, you'd be crazy to not take advantage of the free bronze level membership. Can't get cheaper than free, folks. And you can learn more about all levels of Law of Self-Defense membership by pointing your browser to lawofselfdefense.com/join. Also, folks, if this kind of content is interesting to you and you'd like to efficiently gain a world-class education in self-defense law, we don't know of any better place to do that than to attend a Law of Self-Defense Level 1 class. This is our full-day self-defense law class we've taught all over the country. It's also the class that's been accredited by more than 30 states as continuing legal education for defense attorneys, prosecutors, judges on self-defense. But don't let that scare you away. All the legalese is translated into plain English, so the course is perfectly appropriate for anybody. We do a lot less travel these days than we used to, so we now mostly teach our Level 1 class in a live online format, meaning that I teach the class live, but in a webinar format that we stream to your computer, your tablet, your smartphone. Again, it's taught live. I'm teaching the class live, and there's plenty of opportunity for Q&A, but we can do it without the inconvenience of you having to sit in some dusty classroom for a day, or me having to travel across the country and lose 2 days from family and from work. Our next Law of Self-Defense Level 1 online class is scheduled for Saturday, April 25th. We do have just a few seats available. And folks, we're only doing 3 of these in 2020, and April 25th is one of those 3. So if this is at all of interest, I'd urge you to book your seat now. It's not inexpensive. It's not expensive. Or at least learn more about the class by pointing your browser to lawofselfdefense.com/live online. And in closing, remember, you carry a gun, so you're hard to kill. Know the law, so you're hard to convict. I'm attorney Andrew Branco at Law of Self-Defense. Stay safe.